All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. Morning. This is the time set for oral argument in Ball v. Ball, our case number 1, CV19 0787. If you have a phone on, please turn it off. We're here for oral argument today. Thank you all for coming in. I hope that you're all properly distanced and masked up if you're close to each other. I'll put mine back on as soon as I'm done talking. I think we've got it set up so you can stay at your desk. Yes, we've got mics there for both of you. Each side has got about 20 minutes for oral argument. Appellant, if you want to reserve time, you may do so, but it's up to you to keep track of it. We don't notice or notify you to hold back.
Understood.
We just conferenced this case this morning. We have read the briefs. We've reviewed the record. So we encourage you to keep that in mind as your oral argument. We're pretty familiar with the facts of this case. The proceedings are being recorded, I think live streamed on YouTube right now, so I'm sure there's a cast of 2 or 3 people who are watching. But for their benefit, when you stand up, please state, or when you start talking, please state your name and tell us who you represent so that the audience can watch. All right, and with that, I will turn it over to counsel for appellant. You can proceed.
Good morning, Your Honor. Dave Garner on behalf of the appellant Sean Ball. With me at counsel's table is Paul Riggs, co-counsel. Is it okay if I use the podium?
Or we don't have a mic there, so
okay.
I think it's best if you, and you can sit down, you don't have to stand.
Okay, fine. Thank you. And I presume when I'm arguing I can remove my mask?
I'm fine with that.
Yes.
Okay, thank you. With that, may it please the court, David Garner on behalf of Sean Ball. The appeal in this matter concerns the religious upbringing of the party's 2 teenage children. In ruling that the father was prohibited from taking the children to the Church of Jesus Christ of Latter-day Saints and from sharing with them his beliefs, the trial court committed reversible error in 2 fundamental and independent ways. First, the ruling contravenes the plain language of the parenting plan, which expressly permits the father to take the children to the church of his choice and permits but does not require instruction in the Christian faith. Second, it violates core First Amendment protections which prohibit courts and other governmental entities from deciding issues of religious doctrine, including in this case what is or is not within the doctrinal definition of Christianity. And I will briefly address each of these issues in turn. First, turning to the plain terms of the parenting plan, the trial court's order literally rewrote the parenting plan, turning permissive terms into either prohibitory or mandatory terms. The 2 terms, we refer to them, the first is the church of choice provision. And it says,
Counsel,
yes.
Did your client concede that this was ambiguous before the trial?
No, I don't believe that my client did concede that this was ambiguous, Your Honor. The situation was, my client said that he believed that there might be a situation where he would probably have to consult with the children's mom about the church. But ultimately, that issue is irrelevant. The party's intent, as you've seen in our briefing, is not relevant because ultimately the parenting plan became incorporated into the divorce decree and as such is an order of the court and needs to be interpreted without respect to the party's subjective intent and without respect to parole evidence. So even if...
Setting that aside, if the parties enter into an unambiguous agreement, but their intent is to be ambiguous, does that matter?
If their intent is to be ambiguous?
If the agreement on its face is unambiguous, but it's not what they thought they were entering into, why would we care what they thought they were entering into?
Well, because ultimately it's an order of the court.
No, I'm saying setting aside whether it's a court order
right.
or whether if it was just an agreement between the parties to a contract enter into an unambiguous contract, but they both thought they were entering into something else. Does that matter, or is that a question of mistake?
It doesn't ultimately when it becomes an issue for a judicial decision-making body, because the court's obligation is to enforce the agreement pursuant to its terms. And the only basis upon which it can be interpreted otherwise is if it is ambiguous. And if the terms themselves are not ambiguous, then the court's obligation is to enforce them as written. I think an apt example, in my mind, Your Honors, would be, my client got cited for speeding in a 25-mile-per-hour zone when he was driving 25 miles per hour. Now, of course, it doesn't matter if my client thought the speed limit was 20 miles per hour. What matters is what the actual speed limit is. And the same is true in this case. Ultimately, what it was entered into and what was entered by the court was an unambiguous parenting plan which gave him the right and permitted him to attend the church of his choice. And ultimately, I think it's important to point out that the mother in this case had perfect opportunity to insert provisions which she now argues in court should be interpreted by the court. If it was intended that the may be instructed provision be mandatory, well, they had every opportunity to write in the word shall instead of may. Just like
Or only.
Or only, absolutely. And they
So-
chose not to do so.
So, counsel, if, and I understand this is not part of the record, but if father had, in fact, testified that it was his understanding during the 19 years of marriage that the LDS church was not a Christian church, he'd always believed that, then in your position, that would not matter.
That's exactly right, Your Honor. Ultimately, what is entered into as an order of the court is what is written on the page. And the party's intent is not ultimately relevant to the interpretation of that. And that's clear. Both parties agree that the parenting plan is an order of the court, and the case law in Arizona is also very clear that parole evidence or the subjective intent of the parties is not relevant in terms of the interpretation. So this idea that somehow the intent of the parties should change things is simply not true, and it's not supported by the case law.
And that's because there's not an ambiguity.
There's not an ambiguity. And ultimately, the argument that there's an ambiguity stems from two bases. One is the one that we've been talking about already, which is what was the subjective intent of the parties. I think I've addressed that already. The other argument is, well, there was an instruction at the beginning of that provision that said choose one. And the argument that mother makes is, well, because they chose two, that created an ambiguity. I disagree. And I think the law backs me up on that. The form itself is not mandatory. The parties are free to choose all, any, or a part, or modify it in any way they see fit, so long as they check the boxes that are required by statutory mandate. And in fact, as we pointed out in our briefing, the website from which people can use the form expressly warns them that they should be careful in using those forms because they could lead to unexpected results and things that are undesirable. So they need to be careful. And the form itself tells the parties that they should be very specific in what they want the judge to enter.
So then your position is that instead of looking at it in terms of, here's the contract, you intended something else, you opposing party intended something else, therefore there is an ambiguity, should be the other way around. When there's an ambiguity, then we look at what your intention was, but not before.
Well, certainly, our point is, number one, it's not ambiguous. But number two, in order to get to a position where there is an ambiguity, you have to make the argument that by choosing two instead of one, that created an ambiguity. Our position, Your Honors, is that not only doesn't present an ambiguity, but it affirmatively establishes that the parties understood that they could customize the agreement, that they could tailor it to what they wanted to have entered in by the court. So by choosing two instead of one, they said, we understand we don't have to follow choose one. We believe that choosing two is better tailored to our needs. And in that same analysis, they could have changed the language in the choice of church provision to be more restrictive. And they could have changed the language in the may be instructed to shall be instructed.
But aren't you making the same argument that you're arguing against when you say they understood that they could choose two instead of one? And so aren't we getting into the intent of the parties?
I'm saying even if you went down the path of looking at the party's intent, it doesn't help Mother's argument
Okay.
because it simply says that the parties understood they could alter the agreement. They had every opportunity to do so, and they simply did not. And the only thing that the court is, if there's an argument about what the language of the agreement or the parenting plan meant, you look at the language of the parenting plan. And looking at the language of the parenting plan in this case makes very clear that by using the term may, it was intended to be permissive, as is consistent with its normal, regular, everyday dictionary definition. And it's very easy to look at that. Even if you look on the very same page, the parenting plan uses will in 4 different places. On the next page, it uses will in 8 different places. And throughout the form, there are 23 instances in which the form uses will or shall or will not or shall not. There are only 4 instances in which the plan uses the term may. It's very clear in looking at the form that when the form intended and when the plan intended to make something mandatory or prohibitory, it used the terms will or shall or will not or shall not. Under those circumstances and consistent with clear Arizona case law, when the parties to an agreement or in any other sort of interpretive circumstance use both may and shall in permissive and prohibitory ways, those should be intended and interpreted to have their normal and natural meaning. And it's important to point out that simply because the parties disagree, that doesn't create an ambiguity. Again, the case law that's been cited by Mother is that there's an ambiguity occurs, but you have to look at the language or the text itself. Even that doesn't, the Cohen case doesn't allow courts to get into what people intended. It says, look at the surrounding language. And again, if you look at the surrounding language, it's most closely analogous. The educational arrangements provision is very clear that in that case, it said that the parents shall or will make decisions together. In the religious
Counsel,
situation, it used may.
Oh, go ahead.
You first.
Well, just a short question. What consideration should we give to the fact that that father at some point conceded that the court ought to engage in determining whether the LDS Church is a Christian church or not? It seems that at some point he concedes that the court should engage in that analysis. What do we do with that?
I don't know that I necessarily agree with that point. First of all, father was unrepresented by counsel at the hearing where this issue was raised.
Well, and actually it was, if I could interrupt, it was his attorney that I think, as I review the record, first suggested that the court may need to do this.
I think
July transcript, Cole, who I believe was his attorney at the time, said, I think we're going to have to get into what the definition of Christianity. What is the definition of Christianity?
Right, and I think that if you read the transcript, it's followed up with an indication of the position that we're taking here on appeal, which is that that's not an area where the court is entitled to go or should go. We don't want the government deciding what is or is not Christianity. Now, the point that I want to emphasize with respect to this course, and certainly was an option for the trial court as well, which is even if the court disagreed with our client's position with respect to the intent of the parties, even if the court were to conclude, as it did, that the parties intended for the children to be sent to a Christian church and instructed in the Christian faith, and that was somehow mandatory, contrary to the plain language of the agreement. There is a manner in which the court, consistent with constitutional requirements, could still interpret that provision, and that is by simply looking at the plain language and secular definition of Christianity, which if you look up in the dictionary, it's a person who purports and proposes to follow Jesus Christ. And that's a definition that is consistent with what Mother's expert testified in the trial court, and there's not really any dispute that the church fits within, Father's church fits within that secular definition, and the court does not have to engage in any sort of doctrinal analysis, which is what happened at the trial court. And so simply applying the secular definition of Christianity, Father's church and his beliefs clearly fall within that definition and would have allowed the court to resolve the issue, and the outcome clearly would have been favorable to Father in the trial court. And that's an avenue that is available for the court on appeal. What the court can't do, and what it shouldn't have done, which is engage in deciding issues of doctrinal issues about what is Christianity. And the point that mother felt compelled to bring in an expert is also contrary to the party's argument, their argument that this is all about subjective intent, that this was really about just what two people intended prior to their divorce. An expert would have no relevance. He wouldn't have any more information about what was going on in the individual's mind than either one of them.
What does Clause 2 mean that isn't covered by Clause 1?
Clause 2, and that's an argument, I think, Your Honor, if we're getting to the issue of is Clause 2 superfluous? And our argument is it's not. It certainly, what it does is it represents an agreement between the parties that they are not going to object if the other one instructs the children in the Christian faith. So, for example, if mother decided to convert to Judaism and take the children to the local synagogue, she wouldn't be able to object to the father continuing to teach them in matters of the Christian faith. Now, arguably...
Isn't that covered by Clause 1, which says both parents can take the child to the place of worship of his or her choice? Well,
not exactly, Your Honor. They actually cover two different areas. The first, the Church of Choice provisions talks about what can you do on Sunday or Saturday on your day of, where can you take them? What location can you have them attend? The second provision talks about what religious instruction they can receive. And religious instruction is not tied to any particular location. It's not tied to any particular church. And so they are actually two different areas. Certainly there's some overlap in the sense that when you go to church, you receive instruction in whatever the faith is there. But they're not entirely overlap. At best, they're in the kind of a Venn diagram sort of arena. And ultimately, even if the Church of Choice provision gives a lot of leeway that would encompass a lot of what is intended or is covered by the may be instructed provision, this is not about how much meaning is involved. I draw the analogy to consideration in a contractual arrangement. If there's consideration, the court doesn't get into deciding how much is enough. And in the same way, in this situation, although the meaning of the second provision is perhaps somewhat limited, it's not non-existent. It does mean something. It does represent that the parties have reached an agreement that they're not going to object to the other one instructing the children in the Christian faith. And as that, it passes the superfluity hurdle and has sufficient meaning in order to be enforced.
Counsel, is there a non-Christian religion that refers to their place of worship as something, as a church? I thought church was by definition someplace where a Christian religion would be.
Well, I don't know, Your Honor, is the answer. I think church is used in a very broad sense to encompass all sorts of things. I think if you talk to someone on the street, a church could mean a synagogue, a church could mean a mosque. A church is a more generic term. But ultimately here, the plain language of the parenting plan is unambiguous. And ultimately, when it comes to the First Amendment issues, the judge below got off track, or the court below got off track when it decided to enter into that battle of religious experts, and ultimately framed the issue not as one of deciding what the party's intent was, but in determining what is or is not within Christianity. And that's simply not what our courts or any other governmental institution is allowed to do. And Your Honors, for that reason, we would ask the court to reverse the decision below on any number of grounds. First of all, by enforcing the plain language of the agreement according to its terms. And second of all, even if the court were to uphold a mandatory reading of the instruction provision and a limiting reading of the Church of Choice provision, the trial court's ruling should be reversed based upon a secular definition of Christianity, which clearly encompasses father's faith and is consistent with the expert testimony that was given at trial, and can be done without wading into issues of ecclesiastical nature. I'm happy to take any other questions at this time. Otherwise, I'd like to reserve some time for rebuttal.
Thank you.
Morning, Your Honors. May it please the court, Logan Elia for Kathleen Ball here today. What I want to do is start off by saying what we're not here asking for. We don't want this court to render a decision about whether Mormonism or the LDS faith is Christianity as a matter of law, or that it's not Christianity as a matter of law.
Isn't that what the trial court did below, though?
No, Your Honor, I don't think that's what the trial court did. I think it's fair to say that there was some flirting with that notion insofar as the trial court received evidence from a religious expert. However, the ultimate holding of the trial court specifically references the parenting plan agreement and reads, "It is ordered that the Mormon faith is not part of the Christian faith as set forth in the party's parenting plan." The order below is specifically limited to its context, which is a petition to enforce this specific parenting plan, and it's an order interpreting the parenting plan after it came to light that the parenting plan contains certain ambiguities. And I think that it is beyond dispute that the parenting plan does contain ambiguities. It's a form that directs that you select one of the following three options. Two options are checked, and the first option being that you can take the children to any church of your choice, the second option being that you can instruct them in the blank faith, and Christian is written in.
If we stop there, isn't what Mother attempted to do here a direct violation of the first clause?
What the parties attempted to craft.
No, make sure you answer my question. Isn't what Mother intended to do here directly contradictory to the first clause?
Yes.
So why would we enforce it?
When you say it, I want to be clear here.
The first clause. The first clause says the parties may take the children to any church they want to. And if she says, no, you can't do that, then isn't that a violation? And you said, yes, it's a violation of the first clause. So why would we uphold that determination?
Your Honor, I may have misunderstood your first question. The provision in the second clause that they be...
Before we get to the second clause, let's make sure we focus on that first clause. The first clause says a parent may take the child to any church of their choice, right?
Yes, it does say that.
And now she's trying to limit father taking the child to the church of his choice, right?
Yes, Your Honor.
Okay, so that's a violation of the first clause. So isn't that game, set, match?
No, Your Honor, it's not, because the two clauses need to be read together
Okay, so let's
as a
read
single
the second
provision.
clause. The second clause says that the child may be raised Christian. So that doesn't say shall be raised Christian, does it?
No, it does not say that. Your Honor, our position is that the two clauses need to be read together and that the second clause is a limitation on the first clause. That the parties intended, and that the order, in fact, susceptibly reads that the parents may take the children to any church so long as it's a Christian church.
But you told us started right off, and I'm sorry, but you started right off by saying, oh, we don't need to determine whether Mormonism or the Church of Jesus Christ of Latter-day Saints is a Christian church.
We do not need to...
But then if we interpret it the way you say, then that's exactly what we have to do, isn't it? That we have to determine that Mother was correct when the way you just framed this issue, that the Christian church is a limitation and that Mormonism does not fit within that limitation.
I believe that Your Honor is faced with a choice of deciding on one hand that Mormonism is unambiguously, absolutely as a matter of law, contained within the definition of Christianity, or saying that there's ambiguity contained within this specific order, and that the court may interpret the order itself without reaching a larger question about whether Mormonism is unambiguously Christianity in every context.
I have a hard time finding ambiguity. I'll tip my my hand to you at this point. We have clause 1, which by itself is unambiguous. You would agree with that, right?
No, I don't agree with that.
You think clause 1, saying, assuming this parenting plan only checked the first box,
Okay.
do you think there was any ambiguity?
No, Your Honor.
Okay. If it only checked box 2, would you find that be ambiguous?
Yes, Your Honor.
Okay. That, I think, is probably where I disagree with you. So what is the ambiguity in clause 2? Independent of clause 1, what is the ambiguity in clause 2?
Your Honor, the ambiguity in clause 2 turns on what is and is not encompassed within the definition of Christianity.
But it says may. So how is may ambiguous?
Oh, I'm sorry, Your Honor. No. In light of may, it is not ambiguous, checked alone.
Okay, so clause 2 is, you reverse yourself, or now you understand my question a little better. Clause 2 is unambiguous. If it was standing alone, it says may be instructed in the Christian faith. That's unambiguous. It allows a child to be instructed in the Christian faith, but does not require it, and does not say may only be instructed in the Christian faith. Is that correct?
Yes, Your Honor.
Okay, so we've got 2 unambiguous clauses.
You have 2 unambiguous.
And you want us to say, as a matter of law, that when you check 2 unambiguous clauses that aren't directly in conflict with each other, because I don't see a direct conflict between either one of them. Is there a direct conflict in saying you may be instructed in Christian faith and you may go to any church you want? Take your time. I talk quickly sometimes, so I'm not trying to trap you. I'm just trying to understand your argument better.
Your Honor, below, Father testified that he believed the order would prohibit him from taking the children away from Christianity. That's also Mother's understanding of the order.
Let me interject and ask a question here, just so that I understand. Is it your position that read together, the 2 clauses are saying the children may be taken to any Christian church of the parents' choosing, and that the parents did not believe LDS fit within that?
Yes.
That's your position. Your position.
Yes, that is my position.
You may take the children to any Christian church, although it's not stated here. When they said that, they didn't mean LDS.
Yes, that's correct.
But why do we get to what they were thinking subjectively if there's a way to read it, the plain language, and decide what it means by itself? Why do we have to take that extra step? And wouldn't that be contrary to contract principles if every time 2 parties enter into a contract and the language is clear, and then one of the parties can say, well, that's not what the other party meant. That's not, even though we clearly stated it, that's not what neither of us meant. I know it's 2 questions.
Your Honor, because there's 190 years of ecclesiastical dispute about whether or not Mormonism is Christianity, there's dispute within the dictionary definition itself about whether or not Mormonism is Christianity. If you Google the question, are Mormons, the first suggested search term is, are Mormons Christians? If you go to the LDS website, Your Honor, there are 2 pages devoted to whether or not Mormons are Christians and covering the history of the dispute.
Where do they end up? Do they consider themselves Christian?
Yes, Your Honor, Mormons consider themselves Christians.
Now that we've gone down this road, let me ask you this, because there are members of the LDS Church, there are Jehovah's Witnesses, there are so many different organizations that consider themselves to be under the umbrella of Christianity. I can't think of too many of the names, but it's interesting that this particular one even has the name Christ in the title. And so if the parties meant to exclude any of those religions that consider themselves to fall under the umbrella of Christianity, shouldn't they have been specific about that? And if they didn't exclude it, shouldn't we, rather than relying on another one of the churches with underneath that umbrella to say, no, you're not Christian, you're not, pointing the finger at each other, shouldn't they have been specific? And shouldn't we rely on the definition as understood by the church itself, as opposed to an outside church?
Your Honor, in crafting the agreement, I don't believe that the parties believed that they were being ambiguous, because the parties agreed at the time that they crafted the agreement about the definition of the term. And there's no dispute in the record about that, that at the time they entered into the agreement, neither party.
I don't recall any testimony where he says, I understood at the time that this would not have encompassed the LDS church.
Your Honor, the testimony is from Mother indicating that at the time they entered into the agreement.
But you said there was no dispute, so I mean, that would, to me, would signal that both parties agreed with that.
I only mean to signal, Your Honor, that the claim is expressly made by the mother and at no point refuted by the father. In fact, the father says instead that he has become educated since that time.
I think he said at some point he would acknowledge that there would have been a problem if he had tried to lure them away from the Christian faith, or not lure, but take them away from the Christian faith. Right?
Yes, he does acknowledge that.
Okay. In his mind, he isn't doing that, and
Your Honor, I think...
hasn't come up.
I'm sorry, what?
In his mind, he testified he wasn't doing that, taking them away from the Christian faith.
In his mind today, he claims that he's not taking them away from the Christian faith. Your Honor, they do something interesting in their reply brief, which is to quote a dictionary definition of Christian, but they quote the dictionary definition of Christian as a noun as opposed to Christian as an adjective, as it's used in Clause 2. And I'm looking at the Webster definition of Christian as an adjective, which is of or relating to Christianity. And then Webster's goes on to define Christianity as the religion derived from Jesus Christ based on the Bible as sacred scripture and professed by Eastern, Roman, Catholic, and Protestant bodies. It defines Protestant bodies as any of a group of members of any of several church denominations denying the universal authority of the Pope and affirming the Reformation principles of justification by faith alone, the priesthood of all believers, and the primacy of the Bible as the only source of revealed truth.
Now, if Clause 2 had said may only be instructed in the Christian faith, we might have to get into those issues. But again, I don't understand your argument as to how two independently unambiguous clauses that aren't inconsistent with each other create an ambiguity. So please explain that to me.
Because I don't agree with the argument advanced that Clause 2 is anything other than surplusage. I understand the distinction that's trying to be drawn between instructing in a faith and attending a church. However, I don't believe that that's a distinction that is intended by the language. There's testimony that the parties in crafting this intended that Clause 2 should operate to limit Clause 1. And I think that it is, in fact, susceptible to that reading. And I don't believe that the trial court
So you think
erred.
Clause 2 is under the interpretation that Clause 1 allows taking to any church, you think Clause 2 is completely superfluous?
Yes.
You don't think there's any value to a protection written into a degree that would say mom can continue no matter what to instruct the children in the Christian faith?
I think that with Clause 1 alone...
You don't think that protection has any value?
Right. I think that with Clause 1 alone...
Mom wouldn't want to contract to protect her right to instruct the children as she sees fit, separate from allowing father to take them to whatever church he wants.
I think that the power to take the children to any church they want subsumes the power to instruct them in any particular faith.
What's your authority for saying that it subsumes it?
Because I don't understand how you can view taking the children to a church as not constituting instructing them in a faith.
But even if it does, it protects mother's right to instruct them in Christian faith.
Mother would have that
Separate
right by
from-
virtue of Clause 1, which allows her to take them to any church.
Assuming that,
So she gains
assuming
nothing
that
from...
taking them to church also preserves the right to have them attend a religious school, have separate instruction from a pastor, things like that, that might not be covered by just attending church.
I guess I have two responses to that, Your Honor. First, I think that education is covered separately from religious instruction. And the question of whether or not the children may attend a religious school is a separate question from whether or not they may attend a particular church. But I think that it would be easy to decide a motion to prohibit Mother from having a Christian church or a Christian pastor give instruction to the children in Christianity off church premises based on Clause 1. I don't believe that Clause 1 can plausibly be read so narrowly as to be a geographically limiting function, and that religious instruction may only occur at a building that may be defined as a church. And I'm not sure that we need to define
Catholics,
any
for
building
example,
as a
have
church
CCD.
separately from its religious instructive function.
Catholics have separate catechism classes. Those would be protected by this, assuming you allow Catholicism to be within the definition of Christianity.
I tend to think that it is, Your Honor. I don't think that that's a question before the
Right,
court.
but I mean, but those are separate catechism classes, which are instruction for purposes of Catholic faith outside of attending regular church services.
But I don't think that you can plausibly advance the argument that catechism classes are prohibited under Clause 1 because they're not included
Not
within the
prohibited,
ambit of
but they might
church.
be, a father could bring a action to say, this is not in the best interest of the child. She can take them to church on Sunday, but I don't want my kids going to catechism classes 3 days a week.
Here's another example that fits into that. Jehovah's Witnesses, for example, they do Bible studies in the homes. So a parent could presumably say, you can take them to the Kingdom Hall on Sunday during your parenting time, but I don't want Jehovah's Witnesses coming to the house to give them Bible study. Or I think the LDS Church also, don't they also do Bible studies in the home? So there are circumstances where church activity and instruction happens outside of the place of worship that would be contemplated by the first clause. And a parent,
There is, Your Honor, and there are religious activities that are ancillary to church attendance. I would still argue that such religious activities are subsumed within the power to take the children to a church of your choice, and that would include the broader ambit of religious practice of that church. I don't think that it's appropriate to read Clause 1 as geographically limiting to an area, to a building defined as a church. Nor do I think that the trial court erred in interpreting the agreement when a dispute was brought before the trial court. The trial court is faced with an order, and the parties dispute the meaning of the order. And the trial court then is tasked with saying, what does this particular order mean? And I don't think it is improper in the context of this agreement for the trial court to say, well, I think that it's susceptible to either interpretation advanced by the parties. And so in fulfilling my duty to examine the best interests of the children and enforce the parenting plan as a whole, I'm going to hold a hearing and I'm going to listen to the parties about this, and I'm going to make a decision from that. And the argument that I'm hearing seems to be from the other side is that it was in fact an error for the trial court to have heard any evidence on the subject at all. And instead, the trial court should have interpreted the order in a vacuum.
well, because their position is that there is no ambiguity. And I mean, under the law, if there is no ambiguity, then it would be improper to go behind the agreement, wouldn't it?
Your Honor, I think that
I mean,
we turn in circles here. Yes, their argument is that there is no ambiguity.
If there is no ambiguity, then it is improper to go outside of the agreement, isn't it?
If there is no ambiguity, then the agreement says what the agreement says.
And it would be improper to engage into any other inquiry as to what the parties thought they were doing. And I understand your position is that there is an ambiguity, but if there weren't one.
Candidly, Your Honor, I see it both ways. There's law suggesting that it's improper to look to the party's intent to interpret the court order when it's unambiguous. But there's also a broader duty of the trial court to always act in the children's best interests. And I think that the trial court is within its authority to determine that it can hear some evidence about the children's desires in terms of where they're taken to church and where not in making a decision about how to enforce the order. And I also think that it's within the trial court's discretion to hear evidence about the consistency of interpretation of the agreement across time.
Counsel, we're out of time, so.
Just one question, please, and that is, so your position is that if there is no ambiguity, the court can still reach back and look at the intent of the parties because the court has a duty to determine the best interest. But didn't the court make that best interest determination when it initially looked at the agreement of the parties and approved it?
Yes, Your Honor, the court did.
Okay.
It is always the duty of the court to act as such.
All right, thank you.
Thank you, Your Honor.
Counsel, you have 2 minutes and 45 seconds.
Thank you, Your Honor. I think Judge McMurdy said it best when he said game, set, match when you look at the language of the agreement. There are 2 clauses that the parties checked. They both have independent meaning. They don't, and they can be read perfectly consistently with each other. And that unambiguous reading of that plain language requires reversal of the trial court's decision in this case. And it does so in a way that doesn't get the court caught up into the constitutional mess, which I believe that both sides agree is problematic. We don't want judges deciding exactly what the trial court did in this case, which is what is or is not within the definition of Christianity, and setting up a, quote, battle of the religious experts. But again, even if the court were to look at the party's intent and determine that the parties intended that religious instruction in Christianity be mandatory and that father's choice of church be limited, the only way to interpret that in a way that is consistent with the First Amendment is to look at the secular definition of Christianity. And I didn't quite follow the adjective or noun analogy, but ultimately the dictionary definition is one who professes belief in the teachings of Jesus Christ.
What if the parties had only checked box 2, and box 2 had said may only be instructed in the LDS church, and then father had started attending a fundamentalist LDS church, the offshoot that is operated out of some other area, not Salt Lake? Would it be okay for a court at that point to interpret what constitutes LDS, or would we just say game, set, match?
Ultimately, Your Honor, in those cases, a provision like this can become problematic at any level. I mean, at the edges, there's always going to be a First Amendment issue. Now, in this case, Mother could have narrowed it and precluded some arguments. Certainly, if the provision said the children may be instructed in the faith of the Grace Christian Church on Southern Avenue and 54th Street, that would be a lot clearer. That would allow a court to interpret it in a way that wouldn't require getting into doctrinal issues. But any provision of this nature could create a First Amendment issue. And if ultimately the question that comes before the court is an ecclesiastical or a doctrinal issue, then that's outside the First Amendment. And the cases that we've cited in our brief indicate that courts have indicated that at the fringes, those things can be non-justiciable. A judge is not going to determine what constitutes Catholicism.
Did your client ever assert non-justiciability below?
My client was unrepresented by counsel and would do...
Some of the hearings, not all of them.
Right.
Excuse me, I hear someone in the back speaking. Please, let's allow counsel to argue.
Certainly, the issue where the hearing was actually held, which was the second hearing, he was not represented by counsel and did not raise that argument. So non-justiciability was not raised below. But certainly on appeal, you can make the decision based upon the law for any reason. This is a de novo review.
Thank you, counsel. We will take this matter under advisement and issue a decision in due course.
Thank you.